Questions are very straightforward, except for two questions, which are based on the current debates which are going on. And I think fairly it is based on UPSC pattern with respect to the questions that are asked. How to write these answers? Because there are few questions which are very direct, where you don't have to think much. But certain questions, they expect you to analyze. And this is where, if you are comfortable with the current ongoing debates, then it makes even more complex. So if you are not aware of the current debates, then ignorance is bliss. So you can write anything. But once you are updated, then it becomes very difficult. I am telling you. So ignorance is bliss. If you are not if you are out of touch with what is happening on the contemporary front. Clear? So these two things you keep it in mind. So starting with the first question, the Constitution protects religious freedom in two ways. As you all know that the freedoms that are extended under the fundamental rights are of two types: individual-centric freedoms and group-centric freedoms. So universal freedoms and specific freedoms. You can either categorize them as universal freedoms or specific freedoms. Specific freedoms are group-centric freedoms. So universal freedoms are all those freedoms which are part of Article 14 to Article 24. To Article 25 to Article 30, they are specific to the group. So this is a conscious effort made by the Constitution as part of the nation building process. So remember that. So the Constitution protects religious freedom in two ways. It protects an individual's right to profess, practice and propagate a religion, and it also assures similar protections to every religious denomination to manage its own affairs. Critically discuss. See, critically discuss. When you have the words critically, then what is that you are expected to write? Critically discuss whether individual rights in this regard are in conflict with the rights of religious denomination. First part of the question is too generalistic. It only describes the provisions that are there part of the Constitution. Specifically Article 25 and Article 26. The first part of the question. Second part of the question is more complex. Critically, when you say critically examine or critically discuss, right? What is that you are expected to write? Critically discuss whether individual rights in this regard are in conflict with the rights of the religious denominations. So is there any contradiction between individual rights and group rights? Critically discuss. Critically discuss means how will you explain this? What is that you choose to elaborate your answer? First thing, you go with Article 25 and Article 26 in a brief statement with respect to Article 25, which guaranteed every individuals to preach, protect and practice religion. So as part of practice, the controversy comes. There is nothing wrong in preaching and professing a religion, but when it comes to practice, it led to different controversies in the contemporary India. So first, complexity arises in terms of practice. Second, when you talk about, it protects the individual rights to profess, practice, and it also assures similar protections to every religious denomination. So equality of religion is also guaranteed. Equality of religions is also guaranteed. Equal protection of religion. This is the second point. There is also no controversy with respect to this, except with the first question, where practice has led to controversies in the contemporary context. Right? What sort of controversies you have come across in the practice? Sabarimalai, Jallikattu, there are so many things. Right? Azi Ali Dargah, Sabarimalai, Shani Shinganapur, they are all part of the practice. So the controversy comes with respect to the practice in the contemporary context. So when you are asked to critically discuss whether individual rights Individual rights. When you talk about individual rights, remember one thing. Individual rights are usually in the nature of universal rights. They are in the nature of universal rights that applies to all. That applies to all. But in this regard, whether individual rights in this regard are in conflict with the rights of the religious denomination. So whether individual rights are in conflict with the group rights. Whether individual rights are in conflict with group rights. Critically discuss. What you will write. What you will write. First example is UCC. Uniform Civil Code. Uniform Civil Code. Uniform Civil Code is already part of Article 44, where the state has to make efforts to introduce Uniform Civil Code. But what is the danger with Uniform Civil Code? If Uniform Civil Code is enforced, what will happen? What will happen? Uniform Civil Code means you are trying to universalize. You are trying to universalize the practices. If you universalize the practices, then what should happen to the specific practices? What will happen to the specific practices? What will happen? What will happen to specific practices? Triple Talaq is a specific practice of a particular religion, right? It is not universal. Similarly, untouchability is a specific practice of a particular religion. It is not universal. It is not universal. So it's part of practice. If you want to guarantee universal rights, right? Without guaranteeing universal rights, you cannot address untouchability. You cannot address untouchability without guaranteeing universal rights. Similarly, without guaranteeing, declaring unconstitutional triple talaq, you cannot guarantee universal rights, right? But group rights, why they are part of the constitution? Why they are part of the constitution? Because constitution building process also included, constitution building process also included separate electorate. When Indian constitution is constituted, we discarded the practice of separate electorate and guaranteed group rights. Instead of political representation, we guaranteed social recognition. Instead of political representation, we guaranteed social recognition. So social recognition is guaranteed under Article 26. That means state cannot intervene. State cannot intervene with respect to religious practices. So this is how the religious freedom is guaranteed in India. If you promote Uniform Civil Code, you are trumping religious freedom and establishing universality. Clear? So then what is the point in maintaining a diversity? You understand? What is the point in maintaining the diversity? It will lead to homogeneity. It will lead to homogeneity. Then how to protect? How to protect the balance? We cannot at the same time discard the individual rights because it is leading to discrimination. It goes against right to equality. Triple talaq practice goes against right to equality. So you cannot ignore the injustice to the minority Muslim woman. But at the same time, you cannot trump the religious rights. So what is the way out? What is the way out in this? Should we go for individual rights, overriding group rights? Or should we create a balance between individual rights and group rights? Because group rights also come with public morality, public order and public security. You cannot enjoy rights completely without addressing to the fact that they are also equally significant. So what is the way out you will suggest? You think the constitution is wrong in identifying two sets of freedoms? If you accept that, then we have to also recognize the significance of the group rights, which cannot be trumped in the name of universality or in the name of homogeneity. So you create a balance. Both rights are important. because every provision in the constitution carries equal significance, whether article 25 or article 26. Both carry equal significance. So what is the way out is, it has to be left out to the individual concern when it is a question of religion. So it has to be the question left to the individual concerned whether to go with the uniform civil code or stick to the religious practice. You cannot force. State cannot force, because if state implements uniform civil code and forces everyone to follow homogeneity, universality, then you are trumping religious freedom. And that is the reason why the other day Supreme Court did not deal with Shabarimalai. It referred it to a larger bench. It referred it to a larger bench because state cannot deal with core practices. Core practices. So uniform civil code cannot be enforced. So the option should be left to the individual concerned whether to follow religious law or the positive law. Positive law in terms of uniform civil code. Option left to them. You cannot force them. Both should prevail. Only when both exist, that means you are guaranteeing both individual freedom as well as group freedom. In the absence of either of them, you are undermining the provisions of the Constitution. You are undermining the provisions of the Constitution. Got it? So this is the crux of the matter. This is the crux of the matter. You write this. This is why I said some questions are very direct. Some questions, if you dig, it will lead to more complexities. And this 150 words is not sufficient. 150 word limit is not sufficient, and this question should have been asked as 250 words limit. It cannot be answered in 150 words, because without explaining what is the current status of the debate, you cannot attempt this answer. First you have to analyze what is the current status of the debate, why Constitution maintained both individual rights for religious freedom as well as the group freedom. So we have to maintain that balance because Constitution consciously chose this. Constitution consciously chose this, and we are not here to judge the value of the Constitution. So we adopt that Constitution. So if you go with the Constitution, then both are equally important. Individual rights cannot trump group rights, and group rights cannot trump individual rights. So there has to be a balance. This balance is perfect only when the option is left to the affected individual concerned to choose whether they want to go with the universal law or they wanted to go with the religious practices. Right? In the absence of either of them, you are creating a situation of which is superior and which is inferior. Right? And the Constitution consciously avoided that. Constitution consciously avoided that. So both stand true. Individual rights are important as well as group rights are important. Clear? So in that context, for justification, you can also use, or you can say limits can be imposed in terms of practices. In terms of practices where it leads to oppression and exploitation. Where it leads to oppression and exploitation. Otherwise, without interference, you cannot eradicate untouchability. In the name of group rights, you cannot eradicate untouchability if group rights practice oppression, exploitation and discrimination. Oppression, exploitation and discrimination. You cannot prevent the violation of rights. Clear? So this is a good question. The UPSC standard question, but such questions you will get only 1 or 2 in your paper. Mostly you will get direct questions. And these questions are not expected at the level of GS. One question will be there, 1 or 2, which determines who will score and who will not score. Who will score and who will not score. And that is the reason why paper 2, either you score above 100 or below 80. Either you get above 100 or below 80. This is the distinction. There will be 2 or 3 questions of this nature where you have to address the basic issue in terms of your analysis. Clear? So substantiate it, 2 or 3 examples. two out the examples in terms of your critical evaluation. One this side and the other that side. You have to be neutral. You have to be neutral. You have to justify group rights. You have to also justify individual rights. Right? So never try to trump either of them. Both are equally important as far as the constitution is concerned. Got it? So the key also carries similar argument. The key also carries the similar argument with respect to the entry of the women, which are there part of this thing. But focus when you answer this question, keep this in mind that whatever the provisions of constitution are there, they are of equal significance. Equal significance, and what you are expected to do is maintain a balance. Maintain a balance in terms of group rights and individual rights, and this is what the criticality is. Critically discuss. Right? Critically discuss means express your opinion. Express your opinion with respect to both individual rights and group rights, and signify why individual rights are important, because individual rights guarantee diversity. Every individual is free to choose his religion. Free to choose religion, and that is supplemented by group rights. That is supplemented by the group rights, because groups guarantee the practices. Group rights guarantee the practices, whether it is Jallikattu or Sabarimala entry. Clear? So there are limits imposed with respect to core and periphery aspects of religion. State cannot intervene with the core aspects. State can only intervene with peripheral aspects. So as far as peripheral aspects are concerned, you can have a universalization or you can have universal laws, but when it comes to core practices, you have to maintain the principle of difference. The principle of difference is essential to maintain diversity. Clear? So religious group rights promote the principle of difference, which is essential for the survival of secular fabric of society. Got it? Any questions? Yeah.
The balance that we get by leaving it to the individual, it will work for UCC, but it won't work for the STEP and KPSC.
That is why I said the balance has to be left to the individual concern, affected individual concern. You cannot enforce. If some women like Sabarimala, they are telling that we will wait. So you cannot undermine their freedom. If women are willing to wait till they attain 50 or 60 years age, you cannot force them. So you have to respect that interest also. So individuals acquired rights. So individual rights and group rights are equally important. So no one should trump the other. Right? So don't expect that all questions will be of similar nature. This is one-off question. When I have seen the questions that are there, this is one-off question, but very important, it helps you to score if you can present it better, because most students may not answer it the way it is expected. Moving to the second question, discuss the various key provisions of 102 Constitutional Amendment, which provided the constitutional status to the National Commission for Backward Class. First of all, the Constitution Assembly did not want any other alternate commission or any other alternate power to emerge. So Constitution Assembly or the Constitution never favored any commission. What did we had for SC/STs? Did the Constitution envisage a commission? It only envisaged a special officer. A special officer to monitor the progress of SC/STs. So the Constitution never wanted to promote a parallel authority. A parallel authority in terms of a commission. Right? The Constitution exclusively placed all the powers in the executive itself. So you cannot divide the power of executive. Executive power remains undivided. So it did not want to create a parallel authority. But why we created these commissions, especially backward class commission, is the result of Indira Sahani case. Indira Sahani case was instrumental for the creation of backward class commission, because this is one commission which is being recommended by the Supreme Court. It is created based on the recommendation of Supreme Court under Indira Sahni case, right? What was the Indira Sahni case? Where she wanted inclusion of her caste into OBC. Because BP Mandal based on 1931 census. BP Mandal based on 1931 census identified 52.5% as OBCs. And 22.5% already guaranteed to the scheduled castes and scheduled tribes. So the total reservation that he promoted was 75%. But since Supreme Court fixed a ceiling of 50%, right? So that means you can only accommodate 27.5% out of 52.5%. So Supreme Court wanted a National Backward Class Commission to be formed for inclusion and exclusion of OBCs. So every 10 years, NBC, National Backward Class Commission, to examine who are benefited under the reservation category, exclude those caste groups, and include those caste groups which are not benefited by the reservation. Because you have 52% population and the reservation is only 27%. Right? So for exclusion and inclusion, OBC is created on the recommendation of Supreme Court under Indira Sahni case. Now, why it has acquired constitutional status? The second question. Because it is a statutory body, similar to any other statutory body, but it has acquired constitutional status. Why it has acquired constitutional status? Under Article 338B. This is the second part of the question. If you can understand this, your answer is done. Why constitutional? That means, are there any anomalies in terms of execution of these safeguards? Because all these national commissions are recognized as safeguards against safeguards. They are part of safeguards against safeguard. So you have created a super safeguard in terms of this National Commission for Backward Class. And statutory provision is sufficient enough to guarantee this. But statutory provision only deals with parliamentary laws. So if there is a conflict between state law and parliamentary law, then you need a constitutional status. So constitutional status forces uniformity. Because once it is recognized as part of the constitution, constitutional body, it carries more significance. Because statutory law are based on the provisions that are there part of the union list, not part of the state list. But once you make it a constitutional body, it deals with all powers. It deals with all powers, and this is the major objective for acquiring the constitutional status. Otherwise, it could have remained a statutory body. Statutory body means a law, a body enacted by the law of parliament. Right? Parliament has power only with respect to union list and concurrent list, not with respect to state list. So it cannot intervene. But if it is a constitutional body, it can deal with all the provisions of the constitution, including state list. Including state list. This is the significance for promoting a National Commission for Backward Class from a statutory body into a constitutional body. Clear? Understood? So accordingly, because OBCs, BP Mandal is only constituted at the national level. Prior to that, Uttar Pradesh had already had BC commissions. Andhra Pradesh also already had BC commissions from 1970s. Right? So there are commissions which are created, and there should not be any contradiction between these two. The commissions that are formed with respect to identification of OBCs at the state level should not contradict with the identification of OBCs at the central level. So if you acquire a constitutional status, then OBCs can be recognized uniformly across India. Uniformly across India. So this is another objective for which National Backward Class Commission is created as a constitutional body. Clear? So rest of the features, what it deals with, what it deals with as per the as under Article 46 of the Directive Principles. where it also specifically mentions with respect to scheduled caste, scheduled tribes and other backward class, both economic and educational social backwardness. And what is the criteria for identifying social backwardness in India? How are they identified? What is the criteria for identifying social backwardness in India? Caste. BP Mandal proposed caste as the sole criteria for identifying OBCs in India. Other backward class commissions, other backward castes in India are recognized based on caste as the sole criteria. But Supreme Court modified it, caste as a sole criteria to caste as a dominant criteria. Caste as the dominant criteria, not the sole criteria. And that is where there is a possibility for extending reservations to Muslims, reservations to economically weaker section. If caste remained the sole criteria for identifying social backwardness, then there is no provision in the constitution to extend reservations to other backward class, right? Economically or other religious minorities like Muslims. Clear? So OBC has to bring this uniformity. Bring this uniformity. It is not just based on caste alone as the sole criteria, but caste is identified as the dominant criteria for social and educational backwardness even today in India. Clear? So once you recognize this as a dominant criteria, you can extend reservations. You can extend reservations to include Muslims as well as the economically backward, as 103 constitutional amendment which tries to envisage extending reservations based on economic criteria. Clear? So identify why OBC is created, commission is created first, then expand your answer. Expand your answer. How social backwardness is identified in India and accordingly why you need this. And these features are common to all national commissions, like assuming the civil court powers where it can investigate and promote and where it is consulted even with respect to any policies that are enunciated by the union executive or state executives with respect to the backward class. So this is the objective. But all national commissions, remember, they remain recommendatory, advisory. Why? Because constitution does not want any parallel authority. Parallel authority. They are directly brought under executive only. They can only recommend to executive. They cannot on their own take. Got it? Third question. Examine how abrogation of Article 370 and Article 35A from Constitution and making Jammu and Kashmir as Union Territory will promote the inclusive development in Kashmir Valley, and what are the challenges ahead for Government of India? First point is with respect to the version of the government that it has promoted in terms of abrogation of Article 370. It says because Kashmiris are alienated because of the special status. They are alienated from the mainstream Indian economic development because they are safeguarded by Article 35A, where it prevents external investments. This is the major argument put forward by the government with respect to the abrogation of Article 370, which was countered by Rahul Gandhi. Said just because of real estate you cannot scrap Article 370. He countered by stating that just because you wanted to develop real estate or you want to buy a plot, you cannot abrogate a special status that is guaranteed to a state. Right? So whatever be the intention, because whatever be the political intention, but ultimately it is the development that was in mind, right? And development, when in the process of development anything comes as a hindrance, that has been trumped in the modern context, because there is a majoritarian support because which pursue development with efficiency. So development has assumed an equally significant provision as far as Indian political system is concerned today, especially starting from 2014 when Prime Minister Modi got elected on the development plank. He wanted to bring development, and that is what he has been consciously advocating, even in terms of Sabke Saath Sabka Vikas or Sabke Saath Sabka Vikas and Vishwas. The whole narrative is built on the development plank. Development plan. So development is well, that is what is expected under Article 370. But two things. In the name of development, there was no necessity to demote a state into a union territory. Development is fine. You can abrogate Article 370 because Parliament has the power. But there was no necessity. There was no necessity for the union government to demote a state into a union territory. Abrogation of Article 370 was sufficient. Abrogation of Article 35A was sufficient. But there was no necessity to demote. Right? So why the state is demoted? First question. A challenge which the union government has to address. So this demotion does not come in the way of development. Right? That means you don't want to give it, that goes against the federal spirit of the country. Because states are not subordinate to union government. States also carry sovereign power. States also carry sovereign power, something which is guaranteed under Schedule 7 of the Constitution, where there is a clear demarcation of state powers, state list, where states can exercise their sovereign power. Something which you have taken away. Something which you have taken away. Maybe the political compulsions because they wanted it as a negotiation, a tool for negotiation. You come out of Article 370, we will extend you statehood. A tool for negotiation. Maybe whatever that is there, that is part of the political negotiation. We are not dealing with. But the question is based on development. How it can bring development to the state of Jammu and Kashmir, right? And by scrapping Article 370 and Article 35A. So it is only focusing on economic development or social development, ignoring political development. Ignoring political development because the whatever changes that it has brought, it has demoted. That means it has undermined political representation because now it has become a larger municipality. Once you become a union territory, that means you are directly administered by the president. So political representation is undermined. Political representation is undermined for the sake of economic development. That means you have undermined democracy for the sake of development. You have undermined democracy for the sake of development. Clear? So abrogation, and this is a challenge that the union government has to address. How the union government will restore back democracy? Restore back democracy and give back the power to the people of Jammu and Kashmir. Right to self-determination. Right to self-determination with respect to the provisions that are there under the Schedule 7 of the Constitution with respect to state list. Clear? So can development trump democracy? What would be your answer? Can development trump democracy? Huh? Then how you will develop? Because all authoritarian regimes are known to develop. Because there is no democracy, there is no opposition. There is no opposition, there is no hurdle or there is no hindrance to development. Because whatever decision made by the state is enforced. If you look at development, because capitalism survives in any system. Capitalism does not promote democracy alone. So capitalism can survive in fascism, capitalism can survive in military dictatorship, or capitalism can also survive in democracies. So capitalism does not identify or maintain distinction in terms of the form of government. It can survive anywhere. Capitalism means market economy. That is what you are trying to bring into Jammu and Kashmir by abrogating Article 370. You wanted to bring market economy over state economy. If state economy was sufficient, then there was no necessity for abrogation. So you wanted to promote market economy. You wanted to promote market economy. So you have abrogated Article 370. But by undermining Article 3, the union state, you have also undermined democracy. You have undermined democracy because political representation becomes meaningless. It is directly administered by the union government. So whatever may be the political reasons, but undermining a state or demoting a state is against the federal spirit. Against the federal spirit. And this may lead to future complications as well. Because there is no security to the states now. If the union government wants, it can demote any state. The rights of the states are lost. The rights of the states are lost, something which the union government has to address if it has to maintain the constitutional morality. If the union government has to maintain the constitutional morality, it has to respect the rights of the state. Fourth question, B.R. Ambedkar specified that the office of the President of India was similar to that of the king under the British Constitution. What do you understand by this? Elaborate similarities and differences in this regard. King of England is a monarch, constitutional monarch, whereas the President of India is a constitutional republic. The basic difference is, it is hereditary there, here it is elected, the fundamental difference. But as far as functions and powers are concerned, there are larger similarities. And why we went for this elected head of the state, who is distinctly separate from the elected head of government? Why we went for this? Continuity in administration. Because their monarch extends continuity, here the Republican head of the state extends continuity. So governments can come, governments can go. Pranab Mukherjee was president even under UPA and under NDA. So it does not matter who forms the government. So he maintains an essential continuity in administration, because all power is exercised in the name of president. There are only few powers that the president really exercises on his own. Most of the powers are exercised in the name of the President of India. Same functions are performed in Great Britain under the monarch. But the one major difference with respect to them is, there it is hereditary, here it is elected head. And the second fundamental difference with respect to monarch and the president is, monarch is assumed to be, he can never go wrong. King cannot go wrong. Long live the king. So the king, the institution of monarch has actually brought loyalty to that society. And that is the reason why monarchy still survives. When all other countries move towards democracy or republic, monarchy survived because monarchy is something which actually brings this unifying factor. The loyalty to the crown is what unites the British. So that continues to hold. So here, because the king cannot go wrong, so the individual minister takes the responsibility. So it is not the blame onto the king, but onto the individual minister. Whoever signs on behalf of the king, he is held responsible for any misdeeds. But whereas Indian president does not acquire that. Article 361 only guarantees indemnity to the office of president as long as he remains in power. As long as he remains to the office of president. Once he demits, he can also be tried. President and governors can also be tried for their conduct in office after demitting the office, a provision which is not there with respect to the monarch. Monarch can never go wrong. Monarch can never go wrong. The responsibility is taken by the individual minister concerned on behalf of monarch, but whereas in presidential system, the president is provided with immunity only during his tenure. During his tenure, once he demits office, he can also be tried. He can also be tried, a feature which is not possible with respect to the British monarch. Clear? And apart from this, they acquire similar powers. Similar powers. Both are ceremonial head. Both are de jure head. They are not de facto head. Actual power is exercised by the prime ministers. Actual power is exercised by the prime ministers. But all authority is vested in the president. They remain the commander-in-chiefs. They make the appointments of the Prime Minister and the Council of Ministers. Clear? So all laws are enacted by them. You need the presidential assent and the monarch assent for any parliamentary law to become effective. So similar functions as far as ceremonial functions are concerned. But the differences, one is hereditary, the other is with respect to the individual responsibility. Though the acts are committed on behalf of president, but president can also be tried after he demits office, a provision which is not there with respect to British monarch. And in the key they also added something similar stating that passports, that is a very particular thing because UPSC does not go with particularities. UPSC goes with universalities, generalities, identify the general causes. Identify the general causes in your answer. It does not go with the particular causes, right? There is nothing wrong even if you mention that the monarch acquires the power to assign passports. There is nothing wrong, but I don't think UPSC answers will go with particularities, because what you are expected to know is wider knowledge, not in-depth knowledge. What you are expected is to know things widely, not particularly. Not particularly. Focus on this. All questions. So generalities means identify the generalities instead of going into the particularities. Got it? Fifth question, social audit. Social audit is a process that enables citizens of a Gram Panchayat to assess and demonstrate social, economic and environmental benefits. Elaborate, also highlight some of the challenges faced in implementing social audit mechanism in India. What is social audit? Does it acquire any legitimacy? What is social audit? Why did it has come? Why social audit has come?
Just like that, it audits what all works has been done by the rural Gram Panchayat. These people will discuss, Gram Panchayat people will discuss with the rural people and then they'll discuss.
But acts of law, audit of law is backed by law. Is social audit backed by law? Is it legally bound or morally bound? Morally bound. It is not legally bound because it is not an audit which is conducted on the lines of a professional like CAG. Got it? So social audit, why social audit has come into picture? So identify the shift, where the shift has come. Where the shift has come. Why Gram Panchayat is vested with this power? Because prior to 73rd Act, you had Balwant Rai Mehta, you had Ashok Mehta Committee, or you had L.N. Singhvi, but nobody in fact talked about Gram Sabha. They were only focusing on decentralization of power. Decentralization of power. But Gram Sabha promotes participatory democracy. It is not decentralization, but people directly participating. It is focusing on participatory democracy. Prior to that, whatever commissions that are formed, the recommendations that are based, they only promoted decentralization. So a shift has taken place, and this shift is brought by economic reforms. This shift is brought by the structural adjustment program or the Washington consensus that is introduced into India under Manmohan Singh and under P.V. Narasimha Rao's rule. So you find a shift towards moving from decentralization to participatory democracy. Decentralized democracy to participatory democracy, which is affected by the introduction of economic reforms. Introduction of economic reforms in the name of good governance. Because the package, structural adjustment program package also included good governance. So good governance is defined first time by whom? World Bank. It's a World Bank which defined what is governance. So good governance is introduced as part of the structural adjustment program. And good governance promoted transparency, accountability, responsibility and responsiveness. So the power is taken to the people. Power is taken to the people, where people directly participate and make decisions. Where people directly participate and make decisions, and this is a shift, a clear shift which has taken place. So once when people take decisions, then people are also empowered to audit. Because no work in the Gram Sabha, no expenditure in the Gram Sabha can be met without the approval of the Gram Sabha. All developmental works in the village needs Gram Sabha's approval. And Gram Sabha is a permanent body. There is no election. All adult citizens of India, of the village, qualify to be the members. Qualify to be the members, so they can participate in the Gram Sabha meetings and make appropriate decisions which are necessary for the development. That means people directly participating in the development. They will decide what is necessary for the village. They will decide what is necessary for the village. So it has brought this bottoms-up approach of development. Otherwise, prior to that, we had top-down approach where planning commission decided what is necessary in a village. Governance, it has brought reverse the process, promoted bottoms up. That means you start from the grassroots level. Development focused on the grassroots level, and villages are empowered to make their own choice in terms of developmental activities. Every village on its own will decide what is important to it. School building or hospital or roads or street lights. It is not something dictated by center. So this is where the participatory democracy comes. People decide for themselves. So when you have promoted this, it also empowered the people to also examine how far that has succeeded. This is where the social audit comes. So it is impact assessment. Social audit is impact assessment. How far the developmental projects that have been taken up have succeeded. So you are not only conducting a performance audit, but you are also conducting an impact audit. This is where the crux of the matter lies, where people are provided or empowered to make their own decisions, to participate in the development, to choose what the priorities for development, and also enforce, because without their sanction, no payment can be released. Gram Sabha's approval is essential, right? And thereafter, you also conduct social audit. And if they are not so well versed in terms of auditing, they can always seek the help of the NGOs. Because a layman may not understand the accounts, but NGOs are trained. So by using non-state actors, this is also a feature of good governance. Governance is not based only on public government, but governance promoted a network of administration. A network of administration where you also include private sector or non-state actors like NGOs, voluntary organizations, or corporate social responsibility as part of governance. So it is a network of administration. So where public and private sector together participate in the developmental process. Clear? So network of administration. So you have also facilitated for a provision with respect to social audit. So social audit has come to expand the provision for accountability, where people not only make a choice, but they will also make an assessment of the choice. Assessment of the choice. How far this choice has been effective in introducing the developmental agenda, and how far they have succeeded in promoting development within the Gram Panchayat. So social audit has become another important tool or instrument for the people to bring the authority to accountability. To bring the authority to accountability. But it has its own limitations because people are not well versed. People are not well versed in terms of audit practices. So it has its own limitations, and which is also highlighted in part of the key. What are the issues with concurrent list? In the context of center-state relations, highlighting the recommendations of Sarkaria Commission in this regard suggest way forward. Why the powers are distributed into 3 lists? This is a practice which we had under 1935 Act. federal list, provincial list and concurrent list. Concurrent list emerged there and we continue to maintain that even in the post-independent India. So Indian Constitution also divided the powers distribution, legislative distribution of powers. Remember, it is legislative, not executive. Legislative distribution of powers between union list, state list and concurrent list. Through Article 73, it extended executive power over to the subjects. But actual idea of distribution is legislative distribution of power. It is legislative distribution of power. Executive's power is extended through Article 73. Otherwise, Constitution did not want executive power distributed in terms of this. So, it is legislative distribution of power which is envisaged under Article 7, under the 7th schedule of the Constitution, where it maintained 3. And why this concurrent list? Why they thought there is a necessity for a concurrent list?
Uniformity is desirable but not essential.
Not only uniformity, there are certain things like interstate trade. Interstate trade where the jurisdiction extends. Where the jurisdiction of the state extends. Or the civil issues like marriage, divorce, which uniformly applies to both, to all the states. So there they thought it necessary to have some flexibility option. Because this is a rigid division of powers. A rigid division of powers in terms of union list and state list, because states cannot intervene with union list and union government cannot intervene with state list until other than the provisions as mentioned under Article 249, 250. Otherwise it cannot. Otherwise it cannot. There is some sort of a sanctity that is maintained. Sanctity that is maintained with respect to union list and state list. So they created a concurrent list for a flexibility. Not only uniformity but flexibility, so that the state can also, if required, make amends to the respective laws or to the powers that are enumerated as part of the concurrent list. When you have a federation, which is not a classical federation, under classical federation, only the center's powers are defined rest or all with the states, including residuary powers. American Constitution only assigned what powers the central government has, federal government. Rest of the powers, including residuary powers, are with the states. That is how we identify classical federation. But Indian federation is not like that. We maintain more unitary than federal. The powers of union government are more. The powers of union government are more. So it has acquired overriding powers even with respect to concurrent list. Overriding power even with respect to concurrent list. So here also the states remain insignificant, but we created a provision there also. But states, if they seek the prior permission of the president in enacting a law with respect to the concurrent list, then that law stands true for that particular state. So central law cannot override the state law if it is made with the prior permission of the president with respect to matters that are part of the concurrent list. Otherwise, apart from this safeguard, you don't have any safeguard as far as states are concerned. Center has got overriding powers. Center has overriding powers with respect to concurrent list. And what Sarkaria Commission has recommended is, if you want to maintain the federal spirit of the country, then center should consult the states before enacting any law with respect to the concurrent list. Before enacting law with respect to concurrent list, because it is both center and states both together can use the provisions under the concurrent list. Though there are overriding powers, you have got an edge, but there is nothing wrong in consulting the states. Nothing wrong in consulting the states. In the process, you can also incorporate the views of the state. If uniformity is the basic objective, you also created provision for flexibility. So when you have created provision for flexibility, then states' interests also have to be accounted. Because already the federation is heavily tilted towards the central government. States are, except for state list, they have no power. Even state list, 5 of the powers are transferred to concurrent list, like education, forests, weights and measures, environment, they are all shifted, family planning, to the concurrent list, which otherwise remained part of the state list, right? So the powers of the state remain highly diluted, and the center has acquired exclusive power under Article 3 to destroy any state, So in that scenario, concurrent list, because some powers are transferred to concurrent list, not all, but some powers are transferred to concurrent list, that remain controversial. Why environment could have been transferred to concurrent list? What necessitated? In the name of development. Because states were not willing. If you strictly follow the environmental laws, you cannot have any bauxite mining. If you strictly follow. If you strictly follow environmental laws, you cannot have Narmada Bachaos. You cannot construct Sardar Sarovar projects. If you strictly follow. So this is where they wanted to bring some sort of a uniformity by enacting central laws and forcing the states to follow. So the ball has gone to the union government, where it will dictate what sorts of a law have to be enacted. And this is where the controversy comes with respect to the concurrent list. Otherwise, concurrent list is not so significant. Only provisions with respect to interstate trade or provisions with respect to common interest between the center and state are part of the concurrent list, or provisions with respect to civil marriage that remain part of the concurrent list, right? But once you make it overriding power, then the controversy comes, because center can use it.
Sir, in Ayushman Bharat scheme and then our Telangana state government.
Yeah.
The center is pushing to implement Ayushman Bharat.
The difference between the two is Arogyasri is free of cost, whereas Ayushman Bharat you have to make a premium.
So that is a state list.
But it is optional to the states concerned. It is pushing. It is optional to the states concerned. Because when you look at Ayushman Bharat, prior to Ayushman Bharat, we had Rashtriya Swasthya Bima Yojana, a 30,000 limit. But nowhere in the budget they have specified how much they have allocated and how much it is utilized. Starting from all the budgets every year. Nowhere they have specifically mentioned how much money is allocated, how much money is utilized. And that is what prompted the government to expand it to 5 lakhs. Because hardly anybody is using it. You don't find the details. Go through the budget. Go through the previous year's budget and try to identify what is the allocation. What is the allocation? You don't find the details. Got it? So Ayushman Bharat can be forced, but when you have a free scheme, why people will choose? And now AP government has expanded it to even Bangalore, Chennai, you can go and have treatment there, right? So that is more appropriate for the people of Andhra than going for Ayushman Bharat. But center can, because it's a flagship policy of the center, right? Instead, what they should have done is, instead of using Ayushman Bharat, this is my opinion, similar to universal elementary education, they should have extended universal health care as a responsibility of the state. Or should be included as part of fundamental rights. Right to health. Similar to universal education, where you have made it right to health, right to education part of Article 21A. Health should also be guaranteed. That would benefit the people, not Ayushmans. But anyway, the subject to opinions. Discuss the role of CAG in ensuring accountability of government and public. This is a very direct question. Even last year also they asked. If you know the provisions under Article 148, 149, 150, 151, your answer is made, because everyone knows CAG is also a colonial legacy, and British CAG also has controller powers, whereas Indian CAG does not have controller power. He is only performing audit general functions. And second, even he was maintaining accounts since independence, that is also bifurcated since 1973. He does not even maintain the accounts. The accounts are maintained by the respective state departments and the central departments, and the pro forma for maintaining the accounts is specified under Article 150 through the office of President. So they have to maintain the accounts, and he will examine. And unfortunately, CAG does not have the power for performance audit. He will only perform procedural audit. He will only perform procedural audit, and this is where the controversy comes with respect to 2G scam. 2G scam, where CAG purported that there is a 1,76,000 crore revenue loss to the government by failing to follow the procedures. Because the then government issued spectrum based on first come first serve, and that is not the procedure that is adopted. The basic procedure is invite tenders and allocate spectrum. They failed to do this. So it has been identified that 1,76,000 crore net loss to the government. But 5G spectrum, when it was put for auction, it only fetched 50,000 crore. Whereas the anticipated revenue was 6 lakhs crores. Anticipated revenue was 6 lakhs crores, whereas 5G spectrum only provided netted 50,000 crore. Then 30,000 crore what 2G got is a big amount. So it is considered as presumptive loss. Presumptive loss, not actual loss. Not actual loss. So ever since there has been a demand now to make CAG also a multi-member body, like Election Commission. Because CAG is performing audit of both union government and state governments. Right? He may err. When you are vested with the responsibility to maintain the audit of all the governments, both center and state, it would be more objective if you make it a multi-member body. Similar to Election Commission, which is a multi-member body because it is vested with the power to conduct elections across the country. Clear? So CAG also should come with the powers or make it multi-member, so that there is some sort of an objectivity which comes into this. Otherwise, even political affiliations may also influence. This is what is leveled against Vinod Rai. He was instrumental in unearthing all the scams. Finally, he joined with RSS. So now everyone looks from the prism. Was he really correct? Or his political affiliations dominated in terms of declaring that these are the scams? Are they really scams? So these doubts keep arising, though CAG is prohibited from taking up employment post-retirement. But your political affiliations also matter, right? What political affiliations you carry, that also influences this. So otherwise, this is a very direct question, and these days, every year there is asking a direct question on constitutional bodies, powers and functions. So very easy to answer this question of all the questions without any controversy. In the current Indian judicial system, adjudication takes decades. In this context, discuss the need for alternate dispute resolution mechanisms and the various types of ADR mechanisms available in India. When you talk in terms of objective alternate dispute resolution mechanism, you also have to focus on tribunals. Tribunals are also part of alternate dispute resolution mechanism. Under Article 323A and B, where tribunals are constituted as alternate dispute resolution mechanisms. Only 262 in the Constitution specifically mentions about water dispute tribunal. Water dispute tribunal. But 323A and 323B are inserted into the Constitution through 42nd Constitutional Amendment by Indira Gandhi. She made provision for the reconstitution of tribunals. So they are also part of alternate dispute resolution mechanism only. Clear? So alternate dispute resolution mechanism, because this is how Supreme Court justified the existence of tribunals when it was challenged when it was challenged as against violation of constitution, Supreme Court said if it is expediting justice, we don't have any problem as far as they remain. So alternate dispute resolution mechanism is something practiced in Western countries. Because Western societies, most of the nature of cases are civil disputes. Criminal disputes or civil disputes are separated, and most of the cases that remain pending is in the nature of civil disputes. Civil disputes, you always find a solution in terms of negotiations. If there is a dispute between two civil disputes means there could be some property or money. So if you can come to an understanding, it can be resolved. Okay, if you can come to an understanding, that can be resolved. So there they are aggressively promoted these mechanisms, where arbitration is part of the original agreement itself, where when you enter into some agreement, the party, a contracting party will also have a provision stating that any dispute will come under the Delhi jurisdiction. They will specify that. They will specify that. Otherwise, if people start filing cases across India, he has to run. So, especially with respect to manufacturing, they come with, wherever you enter into agreement, they have a specific clause stating that the disputes will be localized. So, if you have an arbitration agreement, then arbitration can be constituted to resolve the disputes out of the court. And similarly, conciliation, you don't need any agreement. Where two consenting parties come together, if they come together, they can have some sort of a conciliation, means agreement. Where if both the parties agree, you don't have to wait for the long legal process to conclude. Where it can be resolved, settled there and then itself. So these are the two dominant practices in West that we adopted as part of arbitration, right? Arbitration and what is that? Arbitration dispute resolution mechanism. And apart from this, what we also have is this arbitration, conciliation, mediation and negotiations. Mediations and negotiations. Mediations can come even with respect to civil disputes of Ayodhya. What we had? Supreme Court constituted a 3-member committee to mediate. So mediation, all this is possible only, remember, with civil disputes. Alternate dispute resolution mechanism applies only to civil disputes, not to criminal disputes. Criminal disputes, you have to follow the legal process. It goes with the Evidence Act. Civil disputes, they are in the nature of negotiations. They are in the nature of mediations. They are in the nature of conciliations. They are in the nature of arbitration. So only civil disputes can come to this. And if there is a huge backlog of civil disputes, right, then you can have. But criminal disputes, civil disputes also, if a criminal case is filed, for example, a check bounce case, a negotiable instrument act, if both the parties accept for a conciliation, then the court is authorized, court can transfer it to conciliation. Even a criminal case in the nature of dispute in terms of money, like check bounce case, it can also be referred to Lok Adalats. This is what we constituted, where both the consenting parties come to an agreement. Then court will not go with the procedural aspects or evidence aspect and resolve the dispute there and itself. So it facilitated for the feasibility and fast disposal of the cases. Feasibility and immediate disposal of the cases. And this is where the significance of the alternate dispute resolution mechanism, which prevents the piling up of backlog cases. Because why it is promoted? Justice delayed is justice denied. You cannot have cases piling up for years together. So this is one method that is very prominent in the Western societies. So, and that is the reason why in Western societies, judgments are usually expected within a year or two. There is a limited backlog. Here, by the time we complete this backlog, exhaust this backlog of more than 3 crore cases, it will take 100 years. If no other case is filed. Right? Even if the high courts in India are disposing 1,000 cases, Allahabad High Court 1,000 cases every day, still there are 25,000 cases pending with Allahabad High Court itself. That means if no additional cases come, it will dispose of these 25,000 cases in next 25 years. Next 25 years, this is the situation. Clear? So here, this is where the necessity of alternate dispute resolution mechanism, where arbitration, if you already have some sort of an agreement, conciliation, where the state can mediate, where the court can mediate and provide for a conciliation mechanism or mediation mechanism, similar to Ayodhya dispute, Ayodhya title dispute or negotiation. All these only with respect to civil cases. Civil cases where you don't have to strictly follow the Evidence Act, where the court can settle the disputes and resolve the issues.
The setting up of fast track courts in the case of
criminal cases, fast track.
That doesn't come under alternate dispute.
Criminal cases goes with evidence. You go with the procedures. You cannot go with alternate dispute settlement. You can have fast track cases, or you can have special cases, special courts like CBI courts or ED court, Enforcement Directorate Court, right? Civil cases can be dissolved through alternate dispute because there you don't stick to the procedures, and criminal cases they strictly follow the procedures. Because what is important in the criminal case is not the act of offence, the cause of offence, not the act of offence, the cause of offence. What made you to cause this offence? That is important in criminal cases. Not the act. You go and confess, still the trial will go. Still the trial will go even if you confess, yes, I committed this crime. The trial, because it has to identify the cause of offence, not the act of offence. So in this context, they have also constituted Legal Service Authority in 1987, which also helps in extending free legal aid to the people who are in need. Alternate dispute resolution mechanism also essential in India because vast cases of under trials languishing in jails, irrespective of the term of conviction. If they are not financially able to support or have their own lawyer, legal counsel, they remain, because you cannot directly communicate with judge. In alternate dispute resolution mechanism, you can directly communicate to the judge. In the legal course, you cannot. You have to engage through a lawyer. You are represented through a lawyer. You cannot directly communicate to the judge without his permission. Without his permission. So here it becomes even more difficult, and that is the reason why the under trials are also huge number who are languishing in jails. So free legal aid is aimed at providing relief to them. Discuss the constitutional safeguards to ensure the independence and impartiality of the Election Commission of India. How effective is it in ensuring fair elections in the country? What is the safeguard that we have provided to Election Commission? Election Commission, we have guaranteed the tenure. We have a definite removal process. So guaranteed the freedom of functions. So he is not during the pleasure of president. And the most noticeable feature of Election Commission in India, a Indian invention, you can say, a Indian invention to conduct free and fair elections is Model Code of Conduct. This you don't find in any other country. The Model Code of Conduct, this you don't find in any other country. Something which is unique to Indian Election Commission's contribution to the success of Indian democracy. And this Model Code of Conduct addressed two important things. It addressed both criminalization of elections and commercialization of elections. It prevented both. The Model Code of Conduct that Election Commission introduced into India, this is something unique to our Election Commission. This is not there with most of the democracies that go to election. Not only we guaranteed the safeguards, but we also provided them with the freedom to decide their rules. Most significant aspect. That is how it has acquired the power to create its own model code of conduct. It is not something which it has acquired through parliament or executive. The election commission itself acquired this power to define the rules, to define the rules for qualification, to define the rules for conduct of election. In the process, it has also developed the model code of conduct. And if you strictly follow the model code of conduct, it definitely prevents commercialization of elections or the use of money power, because under the model code of conduct you also have provision with respect to limiting the expenditure with respect to each territorial constituencies in India. Clear? So with respect to conducting of free and fair election, model code of conduct is a boon, is a gift the election commission devised to the people of India. But major limitation with respect to election in India is first past the post. The challenge in election in India is first past the post, because even with 21% representation, someone is getting elected, right? So no single party needs absolute majority like 50 plus 1. With 10%, 15%, 20%, 16% also you are getting elected. If the voter turnout is poor, even the election margin is also very less. With 10, 15 or 12% also you can get elected. So this is one of the major limitations that the election commission could not address in conducting fair election. But by and large, though there have been demands on the election commission to reform, starting from Tarkunde Commission, constituted under Janata Party, Justice Tarkunde, then Goswami Commission. There are changes that are introduced. Into the election commission, and which helped in protecting the sanctity of the institution. And the success of Indian electoral democracy is attributed to the conduct of election commission. We are a procedurally successful democracy because we never deviated from conducting election. Time bound, 5 years means 5 years, elections are held, power got transferred. So procedurally, we are highly successful democracy, and that is what the election commission is engaged in. It does not examine whether this democracy really helps you in improving your quality of life. That is not something as the jurisdiction of the election commission. To whatever limited jurisdiction election commission is assigned, it has succeeded, right? In terms of fair conduct of election, the most ingenious device that it has brought is model code of conduct, and it is expanding the list. It is expanding the list under model code of conduct. It is not fixed, because this is the power that the election commission acquired in the conduct of elections. Got it? And no courts can intervene. Once the election notification comes, no court can intervene into the functioning of the election commission. This is what last time Chandrababu Naidu, because there were deferred election. We had almost a 45-day election, national general elections, starting from April to end of May. So no cabinet resolution, no decisions, everything you have to seek the permission of the election commission before you make a decision. So it acquires exponential powers during the election phase, and no court can intervene with respect to the functioning of the election commission or proceedings of the election commission. You can challenge it after the election through an election petition, but not direct interference with respect to the functioning of the election commission. This has guaranteed the independence and autonomy of the election commission. And election commission, it has also become multi-model, a multi-member body. Initially there was resistance by T.N. Seshan, who was the chief election commissioner then. He said, you are trying to dilute the power of election commission by bringing 2 more people. But the constitution only has provision safeguarding the election commissioner, chief election commissioner. The other 2 members, the constitution has no provision. They can be removed with the consent of the chief election commissioner. With the consent of the chief election commissioner. Constitution does not carry any specific provision with respect to the other two members who are part of the multi-member election commission. The constitution made provision only for chief election commissioner. Clear? So these powers, you don't forget to mention model code of conduct, Indian innovation to respond to the challenges of liberal democracy. And the 10th question, privacy. Privacy is a natural right that inheres in all natural persons, and that the right may be restricted only to state action. Critically evaluate the potential impact of this idea on contemporary issues and practices in relation to privacy and the personal data of citizen. The question itself directly states privacy and personal data, and the controversy with respect to privacy and personal data has come with Aadhaar. Aadhaar is one which is invaded into your privacy. So, right to privacy, though recognized under Article 21, what is Article 21 stand for? What is the ground? Principles of natural justice. Article 21 is grounded under principles of natural justice. It is not based on established procedure by law. It has moved from established procedure by law to due process of law. Now Article 21 is read under due process of law, not under established procedure by law. So when you read under due process of law, that means it has adopted the principles of natural justice. Though you have expanded the scope of life, you have expanded the scope of liberty, then privacy also automatically qualify to become a natural right. Privacy automatically qualify to become a natural right because 21 is read under principles of natural justice. What are the principles of natural justice? Justness, fairness and reasonableness. These standards have to be met. It has to be just, it has to be reasonable, it has to be fair. All three principles, 14, 19, 21 combined together. Article 14, which is grounded on justness in terms of creating a just society. Article 19, which has come with reasonable restrictions, reasonableness, and Article 21, which is established based on fairness. So due process links all three. It has created a golden triangle. It has created a golden triangle, and right to privacy is read under golden triangle. So right to privacy also acquires to meet violation of right to privacy has to satisfy all three, 14, 19, 21. It can be examined through 14, through 19, through 21 integrally, not individually. Not individually. This is the significance of Article 21. This is the significance of Article 21, and this is where the court has identified right to privacy. If right to privacy was identified under 19 freedoms, then it would have come with under restrictions. Now 21 unrestricted. Unrestricted. So it has to meet all three standards. The golden triangle, justness, fairness and reasonableness. All three apply to right to privacy. A significant move which recognizes it as a natural extension of freedom. Natural extension of freedom, and that is why located under personal liberty, under Article 21. Clear? So what is that significance? Because personal liberty, your 19 freedoms are part of social control. Your freedoms under 19 are part of social control, but your freedoms under 21 are part of natural principles. They cannot be violated. And Aadhaar violates your privacy. Aadhaar violates your privacy. It violates your privacy because your personal information is in public domain. Because Aadhaar forced you to link with your bank accounts, to link with your PAN account, to link with your voter account. So wherever you are recognized as a citizen of India, it has forced you to uplink. Now whatever activities that you perform, they have come into the public life. You go and make any purchase in any shop, immediately you will within 2 days you will get emails promoting the choice that you make. How they are able to get this data? How they are able to get this data? That means your personal choices, your personal information is on sale for public domain, because what this society is, information society, right? If you acquire the personal choice, personal preference of an individual without any survey, without conducting any survey, when it is available readily, right, it helps you to promote your own business interest. Clear? So this is something which has invaded the privacy of the individual, and this is the reason why Aadhaar bill was contested. Aadhaar bill was contested, and when the opposition, in fact it was Congress which brought this, but when BJP introduced this bill, it introduced this bill as a money bill. Aadhaar bill was introduced as money bill, not as an ordinary bill. And once you know what happens with money bill, so it got passed, but it was challenged in Supreme Court. The progressive Supreme Court failed to recognize right to privacy. Though it is Supreme Court which has guaranteed you to right to privacy, but Supreme Court, in the name of national interest, it said, okay, we don't want to deal with the larger question. It justified Aadhaar. It justified Aadhaar. So this is what has actually provided government a tool to invade into your privacy. And this is not only restricted with respect to Aadhaar. This privacy question is also arise because government also wanted you to store all the social media messages. Whatever messages you transmit, they have to be stored. Then immediately there was a reaction. Immediately there was a reaction on the social media opposing to this move. Then the government relented. Ravi Shankar Prasad, he said, okay, we are not in a hurry to implement. Because the objective is, what they claim, why they wanted to introduce this restriction on social media is, social media messages led to the rise of Occupy movements. Occupy movements in West, like Occupy Wall Street, or Arab Spring in Middle East. The pro-democracy movements, they are all catalyst to the social media messages. So they remain catalyst to the social media messages. So they wanted to have control on social media. Now social media has become a significant tool. It can be manipulated to create a positive political appeal, or it can also be manipulated to use it for ulterior purposes. So it helped in expansion of democratic urge in Middle Eastern countries, and it also helped in uniting people in Hong Kong. Occupy Hong Kong Central, where they are agitating against China's aggression. So they are all part of social media. Now the government wants to bring control on this. Have some sort of a surveillance. Have some sort of a surveillance on the messages that you post on social media. Though legally it is not, legally government does not acquire the sanction, but all accounts are surveyed. All accounts are under surveillance of the agencies of the state. They will examine, because even if they tamper, you don't know. It is not like a written mail where you open and see. It is not like a written mail where you open and see. Your life, your communication, your messages are in the public domain, or especially in the agency's hand, where they can have a surveillance and examine what sort of a messages that you post. Clear? So privacy is becoming important for both, in terms of the messages that you have in terms of your personal life through electronic exchange, or in terms of Aadhaar, where it has forced you to link all your accounts. Otherwise, they say you cannot operate your accounts. So this which was challenged in the court, and the court in fact promoted or sided with the government decision. Clear? So it is violation of privacy. It is violation of privacy. The objective that the right to privacy promoted, it goes against that. The act of government as well as the justification the court has provided. Clear? So here why privacy is admitted to be encroached? One reason always the executive side is national interest. Once you bring national interest, any right can be trumped. Any right can be trumped. Once you advance the national interest or the national security as the defining logic. Clear? Any questions? I didn't touch the points what they are already part of the key because there is no point in repeating that. So what I try to give you is how you examine the question and what is that you are expected to write. What is that you are expected to write, and rest you can follow what the key suggests. I don't say they are not appropriate, they are equally appropriate, but I try to give you a different dimension of looking at things. Because the answer you cannot construct only unidimensional. You have to always remain multidimensional in answering UPSC questions, because remember one thing, UPSC does not go with particularities. It maintains universalities, that means generalized statements, generalized answer, because there will be a model answer. If you go with subjective particularities, you cannot construct a model answer. It has to match with the points that are part of the model answer. So it has to be universal, it has to be generalized. So you don't have to focus particularly or specifically with respect to general the descriptive answers on particularities. Clear? Any questions? Or did I further complicate what your answers are? It would have been better not attending the discussion. Right? At least you are sure of what you know. Right? This is a problem I always create. Once you come, I don't leave you with a satisfied answer, but I help you to probe things further. I never end with giving you a satisfied answer, because that is not the purpose. I always try to help you probe with the new questions. Only when you do that, I think you can answer well this exam. Got it? Yeah. Yes, mobile courts. Mobile courts, Lok Adalats, not Lokpal, Lok Adalats. They are part of alternate dispute resolution. Petty cases. Petty cases, any case. If something is, if there is a theft in your house, you go and lodge a complaint. If FIR is lodged, police has no power to cancel the FIR. It has to occur only through court. Right? If the thief is caught, you are issued summons to come to court every day. As long as that fellow is proved guilt, you have to make rounds to the court. So to prevent all this, you can go to Lok Adalat and ask for the dismissal of the court, because anyway you are not going to recover what is lost. At least you are spared from going to court every day or whenever they call. So this is one mechanism, because until unless court dismisses, FIR cannot be dismissed. First information report, police does not have the power. It is, they don't write. Once they register, they have no power. It has to be cancelled through the court. Clear? So such disputes, what will happen? Lok Adalat is there. There you go. Because otherwise it is also a case pending in the court, where you are not interested, you have given up. You want to come, but still you are forced to come. Still you are forced to come. So there may be cases. All those cases can be dismissed once you conduct Lok Adalat. So it is alternate dispute resolution mechanism which helps in solving cases in thousands in one day, because compromise, that is what is needed, and fix the stamp and declare the case as closed, stands closed, so that you are saved, you are spared from making rounds to the court. Clear? So it is not very popular in India because we don't trust alternate. We only trust court. We don't go to alternate. That is popular in West because they are aware of the provisions. They are aware of the provisions and they seek to this alternate relief. Clear? Anything else? Thank you.